Today we're making sense of the new federal overtime regulations. I'm attorney Jim Phelan from Remley and Sensenbrenner. The Department of Labor recently finalized rules relating to federal overtime requirements, which are to go in effect in December of 2016. Those new rules are expected to have a significant impact upon employers across the country. The rules relate to federal overtime requirements under the Fair Labor Standards Act, which applies to many employers around the country. Essentially, employers who have sales or business done of at least $500,000 in a year, or employees who are engaged in interstate commerce in any way, are covered by the Act. The Act provides for certain exemptions from overtime requirements. Most of you are probably aware that overtime applies, meaning time and a half pay for all hours worked over 40 hours per week. The Federal Act provides for exemptions for employees that are executive, professional, or administrative. There's a duties test, meaning is the employee's primary set of duties executive, professional, or administrative, and also a salary basis test, meaning that in order to truly be exempt from overtime requirements, the employee must be paid a minimum salary. Since 2004, that minimum salary has been $455 per week, or $23,660 annually. That number is being increased substantially as of December. It's changing to $913 per week, or $47,476 annually, essentially doubling that minimum salary in order to be exempt from overtime requirements. Essentially, the new rule means that managers, supervisors, and other employees that were otherwise exempt for years may no longer be exempt. I've been asked a number of questions about these issues. One of those questions is, can I continue to pay certain managers or supervisors on a salary basis? And the answer is yes, employers can continue to do that. The issue is just if that employee is paid under the $913 per week for that salary, then the employer does still have to pay them time and a half overtime for all hours worked over 40 in a particular work week. As stated earlier on, the Act does not govern every employer or every employee, but it does cover many of them, including many here in Northeast Wisconsin. For that reason, it's important for employers to be aware of what their obligations are and what their options are under the new Act. It's a significant change to the law, and it's important that employers know both whether they're governed by the Act, and if so, whether they need to comply with the new rules and how they can do that. An experienced employment attorney can certainly help guide employers through this significant change in the law. As an employment law attorney, I'm able to assist you and your business with any challenges you may have in that area of the law, including compliance with the new overtime regulations. If you have any questions in that area, please contact me here at Remley and Sensenbrenner.